You've seen it in movies 1,000 times. You have the right to remain silent. Anything you say can and will be used against you in a court of law. But here's the scary part. In real life, many people never hear those words at all. And even worse, most people don't understand what Miranda rights actually protect. Today, I'm going to explain what Miranda rights really are, when police must read them, when they do not have to read them, and the one mistake that destroys countless criminal defenses every single day. Part 1. What are Miranda rights? Miranda rights come from a famous U.S. Supreme Court case, Miranda versus Arizona, 1966. The court said police must warn suspects about constitutional rights before conducting a custodial interrogation. These rights come from the Fifth Amendment, the right not to incriminate yourself. The warnings usually include, you have the right to remain silent. Anything you say can be used against you in court. You have the right to an attorney. If you cannot afford one, one will be appointed to you. Sounds simple, right? But here's what most people misunderstand. Police do not need to read Miranda rights every time they speak to you. That's Hollywood fiction. Part 2. When must police read Miranda rights? Police generally must read Miranda rights only when two things happen together. 1. You are in custody, and 2. Police are interrogating you. Both must exist. Let's break that down. Part 3. What does in custody mean? In custody does not always mean handcuffs. The real question is, would a reasonable person feel free to leave? Examples that may count as custody: being handcuffed, locked in a police room, surrounded by officers, or being told you cannot leave. But during ordinary traffic stops, casual conversations, or voluntary interviews, Miranda may not apply. And this surprises many people. Part 4. What counts as interrogation? Interrogation means police questioning or conduct designed to get incriminating information. And officers are trained to do this very carefully. Sometimes it sounds friendly. Sometimes they say, help us understand what happened. We already know everything. This is your chance to explain yourself. If you cooperate, things will go better. But remember, their job is to gather evidence, and your words can become the strongest evidence against you. Part 5. The biggest mistake people make here is the biggest mistake people make. They think, if I'm innocent, I should just explain everything. That instinct destroys cases. Even innocent people get nervous, guess facts, mix up timelines, exaggerate, or unintentionally contradict evidence. And once words are recorded, they can be used against you forever. Police are legally allowed to use many interrogation techniques during questioning. So what should you do? Simple. Part 6. What should you actually say? If police want to question you, stay calm, stay respectful, do not argue, do not resist, and say clearly, I am invoking my right to remain silent. I want a lawyer. Then stop talking completely. Do not explain. Do not clarify. Do not try to talk your way out of it. Silence is protection. Talking is evidence. Part 7. Important warning. Here's another critical point. If you voluntarily start talking after invoking your rights, you may reopen the door to questioning. So once you invoke your rights, stop talking completely. Miranda rights are not magic words, and police are not required to protect you from your own mistakes. You must protect yourself. Knowing your rights can change your life. If you found this video helpful, like, subscribe, and share this with someone who thinks only guilty people ask for lawyers, because constitutional rights exist for everyone. This is Where is My Miranda? And I'll see you in the next episode.